The teasers dropped. The fandom went silent. In an instant, the entire K-pop world was turned upside down. A $22 million bombshell just shattered the industry, and the shockwaves are tearing apart one of the most successful groups of this generation. Welcome to StarScope K-Report.
Yes, welcome.
Join us as we ride the Hallyu wave, uncovering the biggest K-pop comebacks, shocking industry controversies, and major K-drama updates.
Oh, there's so much to cover today.
Right. From internet-breaking rumors to historic chart milestones, we dive deep into the world of Korean entertainment. And, our mission for today's deep dive is to unpack this explosive legal and financial fallout between HYBE and former ADOR CEO Min Hee-jin.
It is a massive, massive day in the industry. The implications of what just happened in the Seoul Central District Court, they are going to ripple outward for years.
Literally years. Yeah. We're going to look at the current, highly fractured state of NewJeans and what this all means for the rights of idols across the entire industry. Because this isn't just about one agency or one group anymore, right?
No, not at all.
It's about the foundation of the idol system itself.
Exactly. We are looking at a story that bridges corporate finance, labor law, and, well, the intense emotional dedication of global fandoms. It's like a perfect storm of corporate governance clashing with raw human elements.
And we really have to start with the headline that is currently dominating, like every single forum and timeline. If this were a YouTube video, the title would be HYBE, just lost $22 million, Min Hee-jin's ultimate revenge.
It's a staggering figure.
It is. That is the massive financial blow handed down by the courts.
Yeah, so let's break down the mechanics of this court ruling.
Please do.
So the Seoul Central District Court dismissed HYBE's lawsuit, which originally sought to confirm the termination of their shareholders' agreement with Min Hee-jin.
Right.
Instead, the court ruled in her favor, validating her right to exercise her put option. And as a result, HYBE has been ordered to pay her approximately 25.5 billion won.
Which is what, like $20 million?
Roughly 17.7 million to 22.3 million US dollars, yeah, depending on the conversion metrics you use.
Wow. I think we need to pause on the financial jargon for a second, though, because a lot of fans see that number on Twitter and just assume it's like a standard lawsuit payout.
Right, it's not damages.
Exactly.
Mm-hmm.
So what actually is a put option in the context of this specific shareholder agreement?
Well, think of a put option as a structural safety net, or like an insurance policy written directly into a corporate contract.
Okay.
It guarantees that a founder or a minority shareholder, in this case, Min Hee-jin, has the right to sell her shares back to the parent company at a predetermined price.
So she gets to cash out.
Pretty much. And it's usually based on a multiple of the subsidiary's operating profit. It is designed to protect founders in the event that, say, the parent company's actions tank the brand's value, or if the relationship just completely sours.
Right, it gives them an exit strategy with guaranteed capital.
Exactly.
So it is ultimate corporate leverage.
Yeah.
But, I mean, HYBE isn't just handing over the check, right? They've already announced plans to appeal the ruling.
They have, yeah. HYBE's core legal argument is that Min Hee-jin breached her contract first.
Right.
They claim she attempted to separate NewJeans from the label, actively sought outside investors to, usurp control of ADOR, and ultimately undermined the company's management structure.
Which was a huge controversy when it broke.
Oh, massive. And from HYBE's perspective, if you breach the foundational trust of the shareholder agreement, your put option should just be null and void.
But the court didn't actually see it that way.
No, they didn't.
The ruling essentially stated that while she may have explored ways to make ADOR independent, or maybe discuss different leverage tactics behind closed doors on Kakao Talk, those actions didn't cross the threshold into a material breach of contract.
That is the crux of the legal distinction right there.
Yeah.
The court basically separated the act of planning or complaining from the act of execution.
Ah, I see.
Yeah. In corporate law, discussing a hostile takeover in private messages is very different from legally executing one. The court found that her actions just didn't constitute a serious enough breach to terminate the agreement and void her financial safety net.
Wow. So in Kpop terms, Min Hee-jin literally just achieved an all-kill in the courtroom.
That's one way to put it, yeah.
I mean, HYBE threw everything they had at her. Audits, massive PR campaigns, legal motions, and the court just handed her a flawless victory. And oh my gosh, we have to talk about the aesthetics of this win, because the visual narrative was just as calculated as the legal strategy.
Oh, absolutely. The contrast between her public appearances is just a masterclass in PR maneuvering.
It really is, because the Knet's reaction to her second press conference was immediate. If you remember the first one, it was all raw emotion, the tears, the blue baseball cap.
Very distressed.
Very. But this time, she walks in absolutely glowing. She's smiling, composed, and wearing this yellow knit cardigan from the Japanese brand Perverze.
The famous cardigan.
Yes. It's about 40,000 yen, so roughly 250 bucks. Netizens instantly dubbed it the fashion style of a winner. And it completely sold out online in, like, minutes.
It was the ultimate power move masked as casual workwear.
Totally.
And, that sold-out cardigan isn't just about fashion. It's a metric of her personal brand power.
Right, she's proving a point.
She wasn't standing there as some disgraced former executive. She was holding court as a cultural icon, demonstrating to HYBE and to the industry that she still commands immense public influence and consumer buying power.
She knew exactly what she was doing. She even navigated the questions about the members perfectly. When the press asked how NewJeans reacted to the legal win, she just said they were ecstatic, that everyone went crazy and they would have celebrated if not for their schedules.
Right, keeping it light.
Yeah, she kept it brief, clearly trying not to put a bigger target on their backs.
Which brings us to the real plot twist of this entire financial saga.
Oh, this is the craziest part.
Having just secured a court order for over $20 million, Min Hee-jin proposed a highly strategic counteroffer. She stated she would completely forgo the 25.6 billion won payout if HYBE would immediately halt all civil and criminal lawsuits and just resolve the disputes.
Wait, really? The whole thing?
The whole thing. And she extended this umbrella of peace not just to herself, but to the members, the fans, the outsourcing partners, and former ADOR employees.
That is an unbelievable pivot. She essentially offered to buy peace for the entire ecosystem with her own settlement money. But, I mean, what is the underlying strategy there? Does she actually expect HYBE to take that deal?
It is highly unlikely HYBE accepts, and she definitely knows that. But from a public relations standpoint, it is a brilliant maneuver.
Because it makes her look so good.
Exactly. She trades the pursuit of capital for unparalleled public goodwill. It paints her as the benevolent protector of the group, and paints HYBE as the vindictive corporate machine if they refuse. It completely boxes HYBE into a corner in the court of public opinion.
It's the ultimate mic drop.
It really is.
But, Min Hee-jin had the leverage of a corporate shareholder agreement to protect her. The idols, they don't have shares. They only have an exclusive contract.
Right.
And as we saw in January, those two documents are treated very, very differently by the courts.
Sadly, yes.
But while Min Hee-jin was popping champagne, the idols themselves were being handed a devastating legal blow. And wait till you hear the 11 shocking reasons they took to the courts. If you need to stay updated on your ultimate bias, hit that subscribe button to keep riding the Holly wave with us, because the reality of what the members are facing is just incredibly heavy.
Yeah, we really need to move chronologically from the high of Min Hee-jin's courtroom victory to the stark reality facing the group itself.
The vibe completely shifts.
It does. The emotional tone shifts dramatically when we look at the members' attempt to free themselves from HYBE. So in November 2024, the 5 members attempted to unilaterally terminate their exclusive contracts with ADOR.
Right. They announced they were walking away, rebranding as NJZ, and essentially trying to launch a new era, independent of the conglomerate.
But in January 2025, the Seoul Central District Court granted an injunction against the members.
Against them, which broke the fandom's heart.
Yes. ADOR, under HYE's new management, successfully filed to legally bar the members from independent activities. The injunction means they cannot sign their own advertising contracts, they cannot promote independently, and ADOR's status as their sole legal agency is preserved until the main lawsuit regarding the contract termination is finally settled.
And the girls didn't just walk away on a whim. They submitted 11 specific grievances to the court, detailing why they felt they had to leave.
Right. Very detailed complaints.
I want to list a few of them because they paint a picture of severe internal dysfunction. Like, they cited the production gap caused by dismissing Min Hee-jin. They cited Belift Labs group Dillid, allegedly copying their core concept.
Which was a huge debate online.
Huge. And they brought up HYBE's leaked internal PR report from May 2023 that literally said, quote, "Throw away the new and start anew."
That was a damaging leak.
Unbelievably damaging. And perhaps most notoriously, Hani testified that a manager at a subsidiary label explicitly told another group to ignore her in the company always.
Right. And the court reviewed all 11 of those grievances. Now, under South Korean contract law, an entertainer can terminate an exclusive contract if the trust relationship is irreparably broken.
Okay.
But the burden of proof is exceptionally high, and it rests entirely on the artist. The court ruled that, based on the materials submitted, it was difficult to conclude that ADOR violated its core obligations to the point of breaking that trust.
Okay, I have to challenge the court's reasoning there.
Go ahead.
In those grievances, they cited HYBE's own chief strategy officer, who was on record noting that he was thinking of, quote, damaging the brand value of NewJeans as a tactic against Min Hee-jin.
Yes, that was in the documents.
If a top executive at your parent company is actively plotting to damage your brand value, how can a judge look at that and claim the trust relationship isn't broken?
From a human perspective, your challenge makes total sense. But you have to look at this through the strict lens of corporate law. ADOR and HYBE are legally distinct entities.
Ugh, technicalities.
Exactly. This is the shield of the multi-label system working exactly as intended. The court looks primarily at the direct contract between the artists and ADOR. Did ADOR fund their promotions? Yes. Did ADOR produce their albums? Yes. Did ADOR pay them their rightful shares? Yes. The court cannot easily punish ADOR for the internal political maneuvering of executives at the parent company, HYBE.
So the multi-label system basically creates a legal firewall. The parent company can create a totally toxic environment, but as long as the subsidiary label is still, like, cutting the checks and booking the studio time, the contract stands.
Exactly. Furthermore, the court noted that allowing the group to unilaterally walk away would cause massive financial losses to the agency and damage the established brand value of the IP.
Because IP is everything to them.
Right. Emotional trust in corporate politics are incredibly difficult to quantify legally compared to, say, financial ledgers and production schedules.
But the human cost of that strict legal interpretation is just devastating to watch.
Yeah.
As of late 2025, we're looking at the tragic fracturing of the group.
It really is tragic.
Danielle's exclusive contract was officially terminated in December 2025. Honey, Heron, and Hyen are bound by the injunction and have returned to ADOR.
Yeah.
Meanwhile, Minji remains in talks, with her status completely in limbo.
And ADOR is moving forward, basically prioritizing their corporate fiduciary duties over the original creative vision.
Moving on like nothing happened.
Pretty much. They have appointed their third CEO in under 4 years, Do-kyong, a former vice president of HYBE's IPX division. They are pivoting hard from a creative-led model to an operational, IP-focused model.
And in a move that felt incredibly abrupt to the fandom, they launched the 2025 ADOR Boys Global Audition to recruit a new boy band.
The machine just keeps churning.
It does. They are actively holding auditions to build a new revenue stream, while 3 members of their flagship group are legally forced back into the building.
It really highlights the sheer momentum of the agency model. But Hani's specific complaint about workplace bullying didn't just end up in civil court. It went all the way to the National Assembly, and it exposed a massive, dark loophole in the Kpop machine.
Well, this is where the deep dive goes from a corporate contract dispute to a fundamental labor rights issue.
Yeah.
Make sure you hit that subscribe button so you never miss a KT update, because this next part changes how we understand the entire idol system.
It really does. We have to look closely at Hani's testimony before the Labor Committee of South Korea's National Assembly. She bravely detailed the workplace alienation she experienced. But the outcome of that testimony was shocking to a lot of international fans.
Total shock.
The Ministry of Employment and Labor dismissed her workplace harassment case entirely.
Because they said she wasn't an employee, which is mind-blowing.
Precisely. Under South Korean law, idols are legally classified as independent contractors, not employees. Therefore, the protections guaranteed under the Labor Standards Act, which includes protection from workplace bullying, guaranteed minimum wage, and maximum working hours, they just do not apply to them. They are completely outside the legal safety net designed for standard workers.
So if they are independent contractors, that means HYBE is legally treating these idols the same way a tech company treats, like a freelance delivery driver or a gig worker.
Legally speaking, yes.
But the glaring difference is control. I mean, a freelance graphic designer can take on other clients, an Uber driver can turn the app off when they are tired. Idols can't do that.
The contradiction is staggering.
It is. The agencies dictate their diets, where they sleep in the company dorms, what they wear, how they speak on live streams, and who they can date.
Everything is controlled.
They micromanage their entire existence to maintain this flawless visual masterpiece for the fandom. But when it comes to basic legal rights and workplace safety, the agency just points to a piece of paper and says, oh, they're just independent contractors.
You've hit on the core legal asymmetry of the entire Hallyu wave right there. The agencies exercise the control of a strict employer, often exceeding standard employment boundaries, but they assume the limited legal liabilities of a client hiring a freelancer.
It's so unfair.
And if we look at the historical precedent, this isn't the first time the industry has clashed over these definitions. It echoes the seismic 2009 TVXQ lawsuit against SM Entertainment.
Right. The TVXQ lawsuit was a massive turning point for the older generation of K-pop stans.
Oh, definitely. 3 members of TVXQ sued over what were widely dubbed slave contracts.
I remember reading about that.
Yeah, they were bound to 13-year exclusive agreements that gave them a fraction of the immense profits they were generating across Asia. That lawsuit successfully forced the Fair Trade Commission to intervene and order agencies to limit standard exclusive contracts to a maximum of 7 years.
Which is where the famous 7-year curse comes from.
Exactly.
It actually started as a labor rights victory to prevent indefinite exploitation.
It was a huge win for artist rights at the time. But what the current situation with ADOR shows us is that while the duration of the contracts was fixed in 2009, the fundamental legal classification of the idol was not.
So they fixed the timeline, but not the status.
Right. 16 years later, they are still legally viewed as contractors. However, Hanny's testimony has sparked a real legislative movement. There is now a proposed bill being called the NewJeans Hanny Act.
And the goal of that act is to specifically combat workplace bullying against idols and redefine their legal protections, right?
Exactly. It aims to close that independent contractor loophole, ensuring that anyone working under the intense exclusive control of an entertainment agency is afforded basic human and labor protections, regardless of how their contract is titled.
So even though the group is currently fractured and bound by court injunctions, their defiance is actively shaking the foundations of the industry.
They are making history.
They really are. They stood up to a multi-billion-dollar corporation, and their willingness to go to the National Assembly might actually change the law for every trainee currently sitting in a practice room.
They very well might. And, that leaves us with a profound thought to ponder as we close out this deep dive.
Yeah.
The NewJeans Hanny Act has the potential to permanently evolve the K-pop industry. It could create the legal safety net that Hani, Minji, Danielle, Heron, and Hyen never had. But at what cost to these specific 5 individuals?
That's the real question.
The evolution of K-pop has always been forged in the fires of contract disputes, but the collateral damage is often the artists themselves. Will we ever see a true 5-member comeback again, or is their fractured state the permanent, irreversible cost of standing up to the machine?
Man, it really makes you look at the entire idol system differently. That $22 million bombshell definitely shattered the industry, but it looks like it's the idols who are left picking up the pieces. You've been listening to StarScope K-Report, where Eric and Minji bring you the stories shaping K-pop, K-dramas, and the global Hallyu wave. Thanks for tuning in, and don't forget to subscribe for more stories that keep the stars shining.